Stands in court with all counsel, and we're ready to proceed. There was a matter that counsel had on their minds that they wanted to discuss before the next witness testifies. What is that?
Your Honor, I had some questions with regard to the areas going to go into. I don't know if you had some issues with regard to my direct and my start there.
Yes, Your Honor. With respect to counsel indicated that she wanted to ask a question of this witness whether he believed that Mrs. Menendez was secretive. And I would object on grounds that's not routine and based on speculation as to that question. I think it's a proper question. The second issue is I intend on cross-examination to get into a session, notes from a session on line 19, in which Kitty Menendez expressed her concern about her sons, Derek and Lyle, that they lacked a conscience and they were narcissistic, and she was told that they were sociopaths. She asked Dr. Summerfield to define those terms, and there was a discussion about that. So I intended to ask him cross-examination about that particular session.
Can we do this one at a time? He's got several areas.
Well, we have two areas. The people's objection to you're going into the opinion of the witness that Mrs. Menendez was secretive.
They have other areas on crossing issues. So my question is, did you want to list all the areas that are at issue, or do you want to just do these one at a time?
Oh, I thought that that was the entirety of what it was.
No, I think
Okay.
other areas.
All right. Well, let's. How long is your direct going to take?
Probably half an hour.
All right. In regards to the secretive aspect.
I did intend to ask him if in the course of treatment he felt that she was able to reveal all of the issues that she had to deal with, and that reaches several levels. One of which is that he continually urged her to be hospitalized because he felt that the issues that she had to deal with were of such a nature that it would not be safe for her to deal with them outside of a hospital setting, because he felt that they would be so painful that, since he had a continuing concern about her suicidality, that she might act out those issues if she were in an outpatient setting, which is why he saw her for the number of times that he did and did not push into particular areas, and it's his opinion that she never reached the core issues. So while he did see certain types of behavior and render certain diagnoses, he did feel that there were major issues that he never was able to reach.
And I take it you would ask him questions relating to what his opinion was about those matters that she did not want to disclose. You might ask a question too along those lines.
No.
No.
No. He gave her the MMPI twice. He scored it. We had it rescored. It all ended with the same thing, that she is a secretive person, that there are things that she's withholding, that there's a need to present an image of someone who is in better shape than she actually is.
Well, did he ask her specifically to talk about certain things and then she refused?
She would go near issues and then back away, and his explanation for why he did not push her to deal with some of those issues was the fear for her life. That his primary goal in therapy was to keep her alive. And he felt that it would take a very long time for her to be able to reach the core issues, which were the source of the great deal of pain for her.
And those core issues were what?
He does not know.
And you don't intend to ask?
He's not going to speculate. I'm not going to ask him to no.
All right, I don't see that this is in any way prejudicial or inclusionary on the part of the witness. It's part of his professional opinion that was part of his diagnosis. As far as this conversation that the people intend to elicit, what is your position?
My understanding, according to what Dr. Summerfield has told me, is that Mrs. Menendez went to Dr. Summerfield and explained to her that Dr. Oziel had indicated that he was concerned about Eric and Lyle being narcissistic or sociopathic, and she asked him to define the terms, and that he opened up the NMTI and told her what the DSM-3, and showed her what the criteria was, and didn't render any opinion on whether they were, as I recall what he told me, he said that any narcissism that might exist would be primarily because of patterning after Jose, and that when I talked to him, my understanding was he said that he indicated that he didn't believe that they were sociopathic, but he indicates now that he thinks he just didn't render any opinion, he just showed her the criteria in DSM-3. So it was just a response to a question she had generated by Dr. Oziel based on his treatment of Eric and Lyle Menendez, and didn't really relate to her issues.
Well, it certainly related to her state of mind when she was speaking to him, did it not?
She asked the questions, she asked what his opinion was about it, and as I've indicated, the information he gave me is what he had told me before was he said that he didn't think they fit the criteria.
Well, his opinion is not the issue, it's her state of mind that was the issue.
But I thought that maybe I misunderstood the directions before. I thought what the court wanted out of these witnesses, or would permit out of these witnesses, was conclusions in terms of diagnosis of her, and not a series of hearsay statements.
Yeah, hearsay statements recounting events that may or may not have occurred in the past. This is not an event. This is her expression of concern regarding the defendants. This is highly relevant to this case, not just some event that may or may not have occurred in the past that she talked to a therapist about. And then the concern is whether that event actually happened and whether what she says should be received for the truth of what is that she said. This is a specific statement of concern that she expressed to the therapist. What time frame was this that this happened?
This happened about a month before the murders. And in addition to that, Dr. Summerfield said that he had spoken to Kitty Menendez several months before that regarding her concern about their sociopathy. And that comports, I believe, with the waiver signed by Eric Menendez regarding Dr. Oziel's sessions with him that covered the January through February 1989 time frame, in which Dr. Oziel was given permission to let the parents know that the brothers had a big problem being sociopaths.
Part of the problem with this is Lyle Menendez never signed any waivers, and he wasn't seeing Dr. Oziel during this period of time, and hadn't seen him for some time. And so I think that we run into real reliability problems in that there's a reference to her having asked a question, what information she had, whether, particularly in Lyle's case, whether Dr. Oziel had any right to discuss any conclusions he might have about Lyle at all. It's certainly an issue. But what I'm concerned about is that there is no indication that this is based on things that are going on, and it's a question that she has. We don't know what information Dr. Oziel gave or what right he had to give her information, or what the context of the conversation was. And she seems to merely be asking Dr. Summerfield for some definitions. And I think it's highly prejudicial. We do not know if she went to him and said, how could somebody say something like this? I don't think it's true.
Well, you can ask Summerfield. You can ask him what she said.
He has a very vague recollection of this conversation. As I indicated when I interviewed him before he indicated to me that he told her that he didn't think they met the criteria.
Did she respond as to whether she felt they did?
He said he just explained to her that he didn't, and that was the end of the issue, and he did not want to spend time on it because it wasn't his purpose in therapy to deal with this outside issue. His issue was her.
Well,
my understanding.
If I could be heard on this,
well, let me hear the people's response.
Dr. Summerfield was this, that Kitty Menendez indicated that she was worried about Eric and Lyle, that she was concerned for lack of conscience, their narcissism, and their sociopathy. He indicated that since he did not actually treat the defendants, he could not render his own personal opinion. But he responded to Kitty Menendez in explaining to her he defined what a sociopath was. So that was his role in it. He said that he never did render an opinion because he never actually saw the defendants. But the relevant portion is the victim's state of mind. That was her relationship with the defendants, and that was her statement regarding how she viewed the two defendants.
All right, let me hear the position of Eric Menendez.
This clearly cannot be her view of how she viewed the defendants, and she's not a psychologist and had no idea what these terms meant. What this is a roundabout way to bring in Dr. Oziel's hearsay and Dr. Oziel's opinion through Mrs. Menendez. According to the information that's been indicated here, the only contacts Dr. Oziel had with the billing sheets show when he talked to Mr. and Mrs. Menendez. It was in February. And then there's been testimony that is having had a conversation with Mrs. Menendez and with Eric Menendez about disowning in May. And this conversation is going on in July.
Why are we assuming that this is all the product of some conversation that Mrs. Menendez had with Dr. Oziel? She said this to Summerfield.
Right. So this is Dr. Oziel, apparently, maybe.
This is before the conversation that Dr. Oziel related to the jury of a reference to sociopath after the parents were killed.
Obviously. Obviously.
Okay.
But that's my concern, is that this now really is the credibility of Dr. Oziel and the competency of Dr. Oziel again. And not anything, how would Mrs. Menendez understand sociopathy? And clearly she didn't. So it doesn't reflect her opinion. She's asking Dr. Summerfield, in effect, if he agrees with Dr. Oziel. Now, what I recall Dr. Summerfield saying with Ms. Lansing and I first interviewed him was that he looked it up and he showed her how, given the descriptions she had given him over the months about her sons and how they reacted and how they interacted, that they clearly didn't fit the description of sociopath. And he said he told her that and showed her that, and that was the end of the conversation.
But apparently he has told Ms. Lansing something else more recently.
Remember now.
So that's pretty much a conflict in what he said, and you two, counsel, can perhaps cross-examine him about the two different statements he's made to you.
I don't think that's the issue of cross-examining. I think to let a bomb-type word like sociopathy and an opinion coming from Dr. Oziel on that term into this trial throws all notions of 352 balancing out the window.
Well, no, the court would balance it, but the court has been balancing all of this evidence that you're trying to introduce regarding the diagnoses of Mrs. Menendez and all the psychiatric history that you're attempting to bring out in her, the testimony that you're offering here. And to whatever extent it might have relevance, or to some extent anyway, it relates to her state of mind. And this is a specific instance where she expressed concern about her state of mind in her state of mind, her concern for the defendants and their behavior.
But the problem, Your Honor, is that this involves so much speculation, because what the court is assuming then is A, she found Oziel's concerns to be legitimate when she asked Dr. Summerfield about them, and B, after the discussion with Dr. Summerfield, she still had that same opinion. And I don't think that the record supports that. I mean, there's nothing to indicate. She may have had a real concern. It may have been a passing influence. And obviously, particularly with regard to Lyle, would have had to have related to something that happened long, long before. There's no indication that it's anything more than just a passing inquiry, and there's no indication that after having discussed it with Dr. Summerfield, she still had any concerns. For all we know, that may have been totally put to rest, and she may not have been concerned at all. And it's July 19th.
Well, regardless of whether her state of mind changed after this conversation, it still would be reflective of her state of mind at the time she had the conversation. And based on what has been presented to me, the court finds that the probative value of this information in regards to her state of mind and concern regarding the conduct of the defendants is relevant and highly probative, and any prejudicial impact of it is substantially outweighed by its probative value, and the court would permit it.
Well, you're not in front of my jury. I don't want this to disappoint my jury, given that ruling.
Yes.
I think what you have now allowed is for Dr. Oziel, who has the credibility of a donut hole.
Well, that's up to you to argue to the jury.
Testify through Dr. Summerfield, who has the memory impaired by his own disabilities over the last 3 years, to a word that this
What disabilities does he have?
to a word that this court previously found under a 352 balancing was too prejudicial to allow in when Dr. Oziel wanted to talk about it concerning November 2nd, and only allowed it in because this court determined that the defense had opened the door to it. Now I take sociopathy no longer has any such prejudicial impact when it comes in this way. I also recall this court telling us on numerous occasions when it came to the testimony of this witness that he would not be allowed to relay such information, as that Mrs. Menendez told him specifically that during the years that her children was growing up, she took all her anger and frustration out on them. That was too remote. That was ancient history.
Counsel, you have misstated everything I have said. I don't know why you've done it, but for whatever audience, I haven't said those things.
I do things for a record.
Okay, well then why don't, okay, you've made your record then, but it's a record that will be reflective of what was actually said, not your remarks. And the remarks I made are pretty much set out in the record as far as why I did certain things. And as far as the testimony or proposed testimony of Dr. Summerfield, it's been documented in a report that was given to the court. See if I have the date. I don't have the date, but it was in support of a motion filed by the defense regarding the admissibility of Dr. Summerfield's testimony. It's part of Exhibit 309. I've read the entirety of that report and the addendum to it in conjunction with rulings on the motions. And I have never said that the conduct of Mrs. Menendez and her state of mind, as stated to the witness, Summerfield, would not be admissible. What I have said is that her accounting or recounting of each and every event that has transpired or did transpire, or she said transpired during the course of her entire life would not be admissible. And the reason for that was because the danger is that the jury would assume that what was said was true. And regardless of the court's instructions, the court would, or the jury would thereby accept these matters as true and not for the offer of state of mind, and the court cited its reasons for it. And as far as a sociopath reference, the court has in mind all the prior discussions we've had and how the matter arose and how the court evaluated at the time in relationship to Dr. Oziel's testimony and the nature of his definition to the defendants after the crime regarding how he defined a sociopathic murder. That is much different than the issue that is now before the court, which is the state of mind of Mrs. Menendez, which is an issue that the defense seeks to prove by the testimony of Dr. Summerfield, not just her actions, but her state of mind, what she was thinking at various times. I assume specifically the times at or near the time the killings occurred. And this was an event that was within a month of that killing. So the court finds that as I've said, balancing it, the way this conversation has been presented to me, the probative value of it substantially outweighs any potential for prejudice.
Could I be heard on two additional objections, Your Honor? One,
yes.
That, if the court is allowing this in as an exception to the hearsay rule under the state of mind exception, it seems that this is not a statement of the declarant's state of mind. It's a statement of her opinion as to the brother's state of mind. Which is different. It's her opinion as to their state of mind. And
their conduct or their state of mind?
I think their state of mind. The form of it is, in essence, Kitty Menendez's opinion at that time that they are sociopaths. That's the value of it to the prosecution. And that is not a statement of her then existing state of mind. It's really an opinion reflecting her belief of their state of mind. So I don't think it would fit within the state of money section for that reason. And second of all, it is an opinion, and hearsay statements are subject to the opinion rule. And I think a separate objection, whether it's hearsay or not, is that it's an improper opinion. Just as if she was testifying on the witness stand, she wouldn't be permitted to state an opinion, her opinion, while an Eric or sociopath. It's still subject to the opinion rule, it would be an improper opinion.
All right, I understand your position, but I don't find that it is a position that is legally correct, and therefore my ruling will stand.
We will not be calling Dr. Summerfield then.
Okay.
Okay, yeah, that's probably good.
The report has been submitted, can't you?
Well, let me, just to perfect the record, if I may, Your Honor, I would just like to indicate what information we would have elicited from Dr. Summerfield, if I may. It won't take long to just go through it. And
No, is this all contained in material that you have already submitted to the court?
No.
You intend to offer or recite what it is that you expected Summerfield to testify about, is that right?
What I wanted to do was just go through just the topics that he would cover.
I don't see that that is really appropriate. He's not testifying, and he's not going to be cross-examined, so how do we know what it is that he would actually say unless he testified?
Well, what I would like to do is make an offer of proof so the record would be clear to the one information he would have produced and will not now be producing. I think I can do it in about 90 seconds if that court will.
Well, with the understanding that there is no way of knowing he would say any of these things, or whether it would be subject to impeachment and what would be brought out in cross-examination, I don't see the value of it. But if you feel that it's appropriate to set forth what you expect this witness might have said, you may do that.
Thank you, I appreciate it. Dr. Summerfield would have testified that he saw Kitty Menendez from February 27, 1987 to August 16, 1989. He saw her approximately 90 times. There was a period from February 8, 1989 to June 21, 1989 in which he was not seeing her. He met Leslie Menendez one time and would have given his impressions of Mr. Menendez.
And what were those impressions?
That he was controlling, dominating, arrogant, not concerned with her well-being.
The report you provided to me indicates that he felt that Mr. Menendez was narcissistic. Was that also one of his opinions?
Yes.
One of those phrases that Mrs. Menendez referred to or asked about in relationship to her sons?
That's right.
Okay.
He would testify that he administered the MMPI to her on 2 separate occasions, and that based on an analysis of those 2 tests, that he found her to be suffering from depression, that she was subject to mood swings, that she would have outbreaks of or angry outbursts, that she was extremely concerned with the appearances, and that people would believe that she was conforming to social norms, that she had a low tolerance for frustration and would be aggressive when frustrated, and that she suffered from chemical dependency. He would also testify that during the time he treated her, she was on the maximum dosage of imipramine and Xanax that was permissible by the doctor, and that she also abused alcohol. He would testify that although he saw her for approximately 90 times, that she had secrets which she characterized as sick and embarrassing, which he felt were very profound and were at the core of her depression, but that he could not get her to deal with those issues and was in fact afraid to have her face those issues if she was not hospitalized. That he urged her on a regular basis to be hospitalized so that he could, number one, isolate her from the forces he thought were reinforcing the secretiveness, that is, her husband. And also because if she ever actually faced these core issues, he felt that the suicide issue, which was always there for her, would be intensified to a degree that it would not be safe for her on an outpatient basis to face these issues. He would testify that she was suicidal during the entire time he saw her, but to varying degrees. Sometimes very, very dangerously so. Other times it was merely something she thought about on a regular basis. He would testify that she told him she wrote a suicide letter for her children to find, and that during the time he treated her, she was in fact hospitalized for an overdose. He would testify that he found her to be depressed then, and believed that depression went back to her childhood, that he found her to be obsessed, that she talked about Louise, the girlfriend, the first day he met her, the last day he saw her, and every day in between, that she described tracking her down, calling her, and that she hounded Jose about it on a regular basis. She could never get over it. He suggested exercise and other activities, but she couldn't seem to get out of her own pain. That her focus was primarily on her problems, which made her unavailable to deal with other issues. That she had sexual issues, which related to both Jose's seeking outside affairs and her own abuse of alcohol. That friends were not available as a resource for her. That divorce was something that she could not do because of her own family history. Those would be the primary areas that he would have testified to.
All right, based upon what you say, it sounds that his testimony would be pretty much identical to that offered and already received by both juries during the testimony of Dr. Cox.
It would just cover
It would be
of time that would bring it up to the
right.
time of their deaths.
And it would be primarily cumulative of the testimony of Dr. Cox. All right, did the people want to indicate those areas that the people would have brought out during cross-examination?
Yes, Your Honor. In about August of 1988, Kitty Menendez expressed her concern about the brothers and their having done the residential burglaries in Calabasas, that she asked for Dr. Summerfield to refer her to a psychologist who could help the defendants. He, at that time, gave 3 names to Mrs. Menendez, one of which was Dr. Oziel. And it was Dr. Summerfield's belief that since Dr. Oziel was the closest one to Beverly Hills, they went with Dr. Oziel. He would be able to testify about her concern about the brothers doing the residential burglaries. In addition to that, he would have testified that on or about February of 1989, Mrs. Menendez expressed her concern about the sociopathy of July 19, 1989, about a month before the killings, she expressed her concern. She said she was worried about Eric and Lyle. She was concerned for their lack of a conscience, their narcissism, and their sociopathy, and asked Dr. Summerfield to explain to her what sociopathy meant. Those things I intended to bring out in cross-examination.
All right. Anything else in regards to Dr. Summerfield?
And we have a letter which I think we're going to be able to correct by stipulation. I had indicated it was one of the letters in the box. It was not. It came from Dr. Summerfield, but I believe Mr. Kazanis has indicated we can clarify that by stipulation, so we don't need to do that.
All right. Then does that complete the discussion regarding Dr. Summerfield?
Okay.
All right. And now your next witness will be who?
Our next witness was going to be Dr. Emery, who's not available.
All right. You indicated that he has been the victim of this fire that's ongoing.
Correct. We assumed that this was going to take the better part of the morning.
And then you indicated also that Detective Zoeller was going to be a witness.
That's Ms. Abrahamson's issue.
Yes,
Are you ready with his testimony?
I'm ready. There's some matters that only go in front of the blue jury. All of this is very, very short. And I need, I just need to make this. It's very brief.
You also indicated that your investigator would be a witness.
She cannot be witness till tomorrow because the materials are being duplicated, which is what I was concerned about. These videotapes.
Which videotapes were they?
Videotapes of our investigators driving the route that were described by Lyle Menendez and Eric Menendez as to how they proceeded after the shootings on the night of August 20th. We were provided a videotape by the prosecution And although our investigators had driven the routes several times, we decided it would be best perhaps to preserve it on videotape, which they have done. And they're also preparing a chart to show the different time sequences, because the videotape doesn't really tell you that. And they'll be ready to go with, she'll be ready to go with that tomorrow morning.
Are we gonna be able to see these videotapes before you actually?
Well, that's why I can't call it today, because I want to get you the video.
We would like to make that request.
All right, well, we'll discuss the proposal regarding further testimony then after we hear what is going to be brought out during the testimony of Detective Zoeller. We will provide counsel a chance to prepare that. You need a few minutes, you said, to do that.
I just need to pull some exhibits up. Just very few areas. I just need to get some photographs to show.
Is there going to be any of this examination before the Lyle Menendez jury or only the Eric Menendez jury?
I have to consult with counsel to see if any of the stuff I'm questioning about came out in front of the Lyle Menendez.
Is there any other witness that the Lyle Menendez jury is going to call other than the investigator?
Today
Ever,
or ever?
ever.
Well, I believe that we are going to try to get Dr. Emery in here as soon as he's available, hopefully by tomorrow. I think it's unrealistic to think he's going to be available this afternoon. There were some issues with regard, Mr. Bird, I think, was talking to Mrs. Bazanich about a stipulation and the tape. I'm not sure what has happened with that.
All right, well, I'll-
Just to expand it, there's a fair number of witnesses that bear on Dr. Oziel that depend upon the rulings that we've been having sessions about over the last few days. There's Juwan Smith.
all right, just to go back to that issue then, Friday afternoon, the court took further testimony in regards to the claim of attorney-client privilege. That was testimony taken in a closed courtroom without the prosecution present. And counsel were going to formalize their arguments to the court and present any additional legal authorities today on that subject. Let me inquire then of counsel whether either side has any additional authorities you wanted the court to review.
Your Honor, we have one case that we have a copy of. It's actually from Arkansas. And we have a copy.
The great state of Arkansas. Okay. And how about the defense? Any additional
No,
authorities?
we had argument based on the cases we've already cited for the court, but no additional cases.
Look for something out of board.
There is actually, I take that back, there's one case we have to take.
Let's take a short break, give counsel a chance to find that case, and also allow counsel time to get ready with the testimony of Detective Zoeller. It's now 10:15, so we'll take a recess and let the juries take a break until 20 minutes to 11. And counsel is expected to be ready at that time to proceed, 20 minutes to 11. We have the defendants in court with all counsel and both jury panels as well. And to everyone, good morning. Glad to see you all here, and we're out ready to proceed with the testimony. The defense may call its next witness.
At this time, Your Honor, the defense would call Detective Zoeller.
Do you solemnly swear that the testimony you may give in the cause now pending before this court shall be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Please take the stand and state your name for the record.
Leslie H. Zoeller.
Detective Zoeller, were you present in the courtroom when one or both, if I remember correctly, of the Menendez brothers were questioned about some papers that were on the coffee table in the family room of the Menendez home on August 20th, 1989?
Yes.
And do you recall that line of questioning had to do with those papers emanating from a particular educational institution?
I don't recall what the substance of the testimony in reference to the papers was.
Now, you were the investigating officer at the scene of this homicide, correct?
That's correct.
And is it part of your responsibility at the scene to determine what evidence or property should be collected and saved for either future examination or future testing or future use?
To a certain extent, yes.
Were there other investigators who were also charged with that responsibility that night?
Well, in addition to the investigators, there's the Identification Bureau that processes the crime scene.
And there are things that they would choose to take because it fits in with their scientific evidence gathering function?
That's correct.
Let me show you two photographs that were previously marked. One of them was 278 and the other 250. Do you recognize, with respect to 250, the larger one, what piece of furniture it depicts?
This is the coffee table in the den.
That's the scene of the homicide.
That's correct.
And 278. Do you also recognize what's depicted there?
Yes, this is the photograph. 278 depicts the floor right below the coffee table and the leg to one of the legs of the coffee table.
Okay. Now, calling your attention to the printed, there is a printed document of some sort on the floor next to the leg of the coffee table, correct? That's
correct.
And it's of contrasting ink colors, blue and white, correct?
That's correct.
And can you determine whether that document pertains to an educational institution of some sort?
Yes.
And what tells you that it has to do with a school?
Because it says UCLA on it.
Okay. Doesn't it also help, though, that it says how to enroll?
Yes.
And the reference to UCLA on it is in the right-hand edge of what we can see of this document. And above UCLA, the word park appears.
That's correct.
Now, is there any handwriting on that form that you can see?
No.
Did you examine that form the night of August 20th or the morning of August 21st, 1989?
I did not examine it, no.
Was it taken into evidence or into the custody of the Beverly Hills Police Department?
No, it was not.
Now, can you also see right next to that particular enrollment, it looks like an enrollment information sheet, does it not?
It does.
Now, you see right next to that on the floor, there is a white envelope.
Yes.
And can you see the postmark on that envelope on the floor?
Yes, I can see it.
And what is the postmark of that envelope?
It says Princeton, and I can't read the date on it.
Can you see the New Jersey part? NJ.
No.
Now, turning your attention to 250, the larger photograph, that's the top of the coffee table, correct?
That's correct.
Would you describe for the jurors what items appeared to be on the top of the coffee table that you can see from that photograph?
In the photograph, there's a folder, and it's labeled Lyle at the top of the folder with paperwork on top of it, envelopes. Next to that is a Michael Jackson cassette tape, a lighter.
Cigarette lighter?
That's correct. A Kleenex, another paper with a form paper that's been printed, another napkin or Kleenex, a watch, a glass with some liquid in it, another glass with a spoon, and
That's the glass that you previously testified in at one time appeared to hold blueberries in a white substance.
That's correct.
Okay.
Some type of a leather-bound notebook with a napkin and another some more paper on it.
That paper that you're just pointing to, the one next to the napkin, it says something Ford, does it not?
Yes,
Like the name of the dealership?
yes.
Okay.
And a small piece of paper next to that with another cigarette lighter, a pipe, newspapers with what appears to be a TV guide on top of the newspapers.
That's the Los Angeles Times TV section, is that what that appears to be?
It appears to be, yes.
What were the dates on the newspapers?
I don't recall now.
Did you examine them?
I looked at them. I didn't examine them, no.
Now, I want to call your attention to this other envelope, the one that's on the top of the pile, that's on the right edge, as you look at that photograph of the coffee table. Does that envelope appear, I mean, can you read on the return address, the top line of the return address?
Yes.
And what does it say on the top line of the return address?
University of California.
And then if you look at the third line of the return address, can you see the city, Berkeley?
It does appear to be Berkeley, yes.
And you can see the postmark very clearly, can you not?
Yes, that
Also
does.
saying Berkeley.
That's correct.
And to the best of your knowledge, UCLA is not at Berkeley, correct?
That's correct.
There is a campus of the University of California known as Cal that is at Berkeley,
That's
correct?
correct.
Now, where in that photograph do you see anything filled in by Mrs. Menendez?
I don't see anything in this photograph at all.
Where's the pen?
I don't see a pen.
Where's the pencil?
No pencil.
No crayons, nothing, no writing implements. Is that correct?
That's correct.
You testified previously, Detective Zoeller, about the two rifles that were located inside the Menendez home. Do you remember that?
I do.
And you testified, I believe, that the rifles were located in Mr. Menendez's closet. Is that what your testimony was?
That's correct.
Now, subsequent to that testimony, did you go back to your file and observe a report written by other Beverly Hills officers that indicated that the rifles were in the closet that had the mirrored closet doors?
That's correct.
And then did you look at your crime scene video and note that the closet with the mirrored closet doors was Mrs. Menendez's closet?
That is also correct.
So when you testified under oath here that it was Mr. Menendez's closet, were you lying?
I was in error.
You made a mistake, is that correct?
That's correct.
And you're an experienced police investigator, is that right?
Yes.
And this was your case from the moment you were called to the scene, is that right?
Mine along with Detective Linehan, that's correct.
And did you, after you had looked at this report from the other officers and viewed the crime scene video, called me up and say, Miss Abramson, I made a mistake on the stand?
No, you brought it to my attention.
Several days later.
Correct.
But you didn't call me when you found out, is that right?
That's correct.
Are you familiar with a business in Van Nuys called the Target Range and Gun World?
Yes,
And is that business located on Cohasset Street in Van Nuys?
it is.
And is the Target Range and Gun World a two-part business, if you will?
Yes, one is on the south side of the street, the other is on the north side of the street.
And the part that's on the north side of the street, is that a gun store in which firearms and ammunition are sold?
It is.
And the part that's on the south side of the street, would you describe what that is?
It's the gun range, a shooting range.
And it's an indoor range, is it not?
Yes, it is.
The shop that sells the guns, is that a relatively small store?
Yes, it is.
And at that particular store, do they, or did they in 1989 sell Fiocchi ammunition?
Yes, they did, and they still do.
And did you, in fact, well, strike that, as part of your investigation, did you attempt to track down the various outlets in the Southern California area that sold Fiocchi ammunition?
Yes.
And was that because it had been indicated to you by the Scientific Investigation Division that the kinds of shotgun ammunition that was used here was Fiocchi type?
That's correct.
And did you get some sort of printout from the Fiocchi people showing which various gun outlets sold their ammunition in August of 1989?
Yes, I did.
And Target Range and Gun World was one of them, correct?
That was on their list.
And do you recall personally going to the Target Range and Gun World to investigate?
Yes, I did.
Do you recall when you did that?
Not exactly. I remember getting the Fiocchi information, I believe in January of 1990, so it was after that. I would assume in the next month.
But it wasn't any event before Eric and Lyle Menendez were arrested?
Before they were arrested, that's correct.
And do you recall whether or not you either showed a photograph of Eric and Lyle Menendez to the employees or left a photograph with them?
I showed them photographs of the defendants at the time I was there, and they indicated there was other employees that were not present, so I left the photos with them.
Are you familiar with any other indoor firing range and gun store combination in Van Nuys?
No, I am not.
Are you familiar with any other indoor firing range and gun store combination in the Valley?
There's one in, it's either Agoura or Calabasas area. And there's also one in, I believe it's Reseda. It's Reseda Boulevard and Parthenia. That's all I can recall right now.
And are they set up the same way with the Target Range across the street?
No, they're all one store.
So this is the only one that's two-part?
That's correct.
Now, I want to take you back to your original interview with Amanda Adams Geyer. Do you recall that?
Yes, I do.
And can you tell us the date of the first interview you had with her?
It was March 14th of 1990. It was about 3 o'clock, if I recall.
And you interviewed her at the Big Five store in San Diego?
Yes, I did.
You're sure it was a Big Five store, is that correct?
Yes, I am.
Like the closet, is that right?
Okay.
Now, do you recall asking, she was then Amanda Adams, is that right?
That's correct.
Okay, she hadn't married Mr. Geyer yet? Okay. Did you, when you interviewed her, show her the paperwork for the sale of the Mossberg shotguns that's been introduced into evidence here?
Yes.
And I believe those are technically called ATF 4473 forms.
That's correct.
So you had already obtained those papers from the Big Five store, correct?
I believe at the time that I interviewed her, they were still at the store and possibly still in their notebook.
But I mean, you had them. You had been shown them before you interviewed her.
That's correct.
And were you also shown the logbook in which their inventory of gun book in which the purchasers sign off when a gun is purchased?
That's correct also.
Okay. So she saw all four of those documents.
Yes.
And did she tell you during the course of the interview that she had no recollection whatsoever of that sale?
She stated she didn't remember the sale at all. That's correct.
And she couldn't tell you anything about the people or person?
That's correct.
She couldn't tell you anything about the time of day?
That's correct.
She couldn't tell you anything about anything that the person or people might have said during the course of the sale?
That's correct.
Now, changing the subject, did you attempt to verify the date upon which Dr. Oziel reactivated his home alarm system?
Yes,
And did you determine that it was on March 16th, 1990?
yes.
Your Honor, that's all I have on direct in front of both juries.
All right, any examination on behalf of Lyle?
No, Your Honor.
Any cross-examination?
Yes, thank you. Detective Zoeller, you were asked questions about the crime scene photograph that you have in front of you.
Yes,
At the coffee table. And
That's
you
correct.
were asked whether you had picked up the bloody UCLA documents on how to enroll and on parking.
that's correct.
Now, on that day, August 20th, or the early morning of August 21st, did you know that the defendants were the killers of their parents?
No, I did not.
On that day, did you have any reason to believe that you should seize those documents to see if there was any writing within those documents?
No,
In fact, you saw to it that photographs were taken of the crime scene so that the jury could see what was next to the victim in this case, Mrs. Menendez, correct?
Your Honor, I'm going to object the question.
Rephrase the question.
Were you the one, Detective Zoeller, to make sure that photographs were taken at the crime scene?
yes,
And that is one of the photographs that was taken at the crime scene next to Mrs. Menendez, is that correct?
that's correct.
And these letters, documents from UCLA were found next to Mrs. Menendez?
That's
I would
correct.
object to the form of the question, Your Honor. They are neither letters nor are they plural documents from UCLA.
Rephrase the question, the answer is correct.
This document that you see in that photograph in front of you, that's Exhibit 250, is it?
That's correct. 250 is the larger photo.
And the documents that you see in the other photograph,
Or just 278.
278, is that the document that was found next to Mrs. Menendez?
That's correct.
And are those bloody documents?
They are.
And are they identified as UCLA documents?
I'm going to object again, Your Honor, to plural. There's only one document.
How many documents are there,
That's from UCLA.
Mr. Zoeller?
There's one document.
Is that a multi-page document?
I can't tell by the photo and I don't recall.
Okay, but it indicates how to enroll and also has information on parking?
It's from the registration office and it says park, but it's cut off with UCLA under it. So I can assume it's parking.
And on the table, Exhibit 250, there were other documents actually on the table that weren't next to Mrs. Menendez on the ground, correct?
That's correct.
And one of those documents was a letter from the University of California at Berkeley.
Yes.
Object to the form of the question, Your Honor. It's calls for speculation.
All right, objection sustained, the answer is stricken. You're referring to the envelope, is that right?
Yes.
Okay, without reference to what might or might not be inside it, why don't you just refer to it as an envelope?
Is it simply an envelope that you see in Exhibit 250?
It's an envelope with paperwork underneath, but the only thing that's identifiable is the envelope itself.
And you likewise did not seize that envelope, is that correct?
That's correct.
Now, you had testified earlier, Detective Zoeller, that you found 2 rifles in the closet of the parents, Mr. and Mrs. Menendez. Is that correct?
That's correct.
And your testimony is it was in Kitty Menendez's closet. That is, each parent had their own separate closet.
I think I testified that it was in a closet that I thought was Jose Menendez's closet.
And is it correct that it was in Kitty Menendez's closet?
That's correct.
And these two 22 rifles, were they 22 rifles?
Yes, they were.
They were unloaded?
Yes.
Correct? And they were propped up against the wall in the closet?
Yes.
And you didn't seize those rifles either, did you?
I did not know.
Was it because you believe that shotguns were used in the killings?
Object to the form of testimony.
All right, it's leading, rephrase the question.
Why was it that you didn't seize these 2 rifles, 22 rifles?
Because the victims were shot with a shotgun, and I didn't feel that they were evidence to the crime.
You were asked questions about Amanda Adams, that you went down to San Diego on March 14th, 1990.
That's correct.
Did you first speak to the manager at the Big 5 store in San Diego, Reggie Clevitt?
Yes, I did.
And sometime later you spoke to Amanda Adams?
Yes.
Now, had you recently gotten information about the possible purchase of shotguns by these defendants shortly before your trip to San Diego on March 14th of 1990?
Yes, I did.
Was that just several days before?
Approximately a week before.
And when you went to this particular Big 5 store in San Diego and you spoke to Mr. Clevitt, did you get information that you connected to the defendants in this case?
Yes.
And that was a document indicating that a Donovan Gaudreau's license had been used in the purchase of 2 shotguns?
That's correct.
Now, when you got this information, did you get further information from Mr. Clevitt about who the salesperson was?
Yes, I did.
And did you locate that person?
Yes, she was also working at the time.
When you spoke to, and that is Amanda Adams?
That's
When you
correct.
spoke to her, was she out in the store?
Yeah, she was a salesperson in the store.
Where was she in particular?
I don't recall. She was not in the gun department, which is where I was.
But she was actually on the floor that she would be trying to help out customers?
I believe so. She might have been in the back storage area. I'm not sure whether she was actually in the store, on the store floor.
At the time that you spoke to her, did you show her the documents
Yes.
reflecting the sales?
Yes, I did.
And did she have time to think about the sales?
Objection, or cause for speculation.
Rephrase the question.
Would you describe your first contact with Amanda Adams?
I asked the manager, Reggie Clevitt, who the salesperson was. He identified Amanda Adams. I asked if she was working. He said yes. She was summoned over to the area. As she came over, I explained the investigation briefly and showed her the ATF forms and asked her if she recalled the sale depicted on the forms.
Now, did you take her back to a back room so that she could sit down and take a close look at the documents?
No, I did not.
How long did this discussion take between yourself and Amanda Adams?
Totally no more than 10 or 15 minutes.
And at that time, she told you that she didn't recall this particular sale or these sales.
That's correct.
Sometime later, you got further information from her after having a chance to reflect on the sales. Is that correct?
Your Honor, cause for speculation.
Objection made to the following question.
Sometime later, Detective Zoeller, did you get detailed information from Amanda Adams
Object.
regarding the sales?
Objection, hearsay, no foundation for an exception.
Objection overruled. Question be answered.
Yes, I did.
I have nothing further at this time, Your Honor.
You're aware of the fact that Amanda Adams testified in front of the grand jury in 1992,
Yes, I am.
and that in front of the grand jury, she again had absolutely no recollection of the sale?
I'm not aware of what she testified in front of the grand jury.
The only time you got any information from her that was different from that was in June of 1993, correct?
That's correct.
So for 3 years, she never gave you any indication that she remembered anything about the sale. Isn't that right?
That's correct.
She didn't call you back the next day and say, gee, now I remember after the March 14th interview, did she?
No.
Nor the next week, nor the next month, nor the next year.
Not until in June of 93. That's correct.
And you contacted her in order to prepare her to testify at that time. Isn't that right?
I called her in reference to her additional information.
Well, how did you know about the additional information if you hadn't talked to her yet?
I got the information from the district attorney's office,
And where did they get it from?
from Amanda Adams.
So they talked to her before you did. Is that right?
That's correct.
Before you did, at least in June of 1993.
That's correct.
And who in the district attorney's office do you believe talked to her before you did in June of 93?
Mrs. Bozanich.
Now, you did have with you in March of 1990 photographs of Eric and Lyle Menendez, correct?
That's correct.
In fact, you had them arrayed in like a lineup type card, correct?
Each one in a separate card. That's correct.
Right. And you showed that photo array to Miss Adams.
That's correct.
And she was unable to identify, well, let me see. Actually, didn't she pick out a photograph of someone totally unrelated in one of those spreads and said, this person looks familiar, or words to that effect?
That's correct.
And did you then follow up and ask her, did that person look familiar in reference to this sale?
That's a question I asked her.
Yes, and then she told you once again, I have no recollection of this sale.
That's correct.
Now, you didn't show her these photographs while she was waiting on customers on the sales floor, did you?
No, I did not.
It was rather important for you to establish who purchased, well, strike that. At the point when you went to San Diego to look for shotgun purchases, you had already received information that Eric and Lyle Menendez had some conversations with a Dr. Oziel, and Dr. Oziel had talked to his girlfriend about those conversations, had you not?
That's correct.
That's what sent you to San Diego. Judalon Smith told you.
That's correct.
So you certainly were looking for a link between Eric and Lyle Menendez and the purchase of shotguns.
I was.
That's why you took their photographs to show to any salesperson who might have waited on them.
That's correct.
This was a very important potential piece of evidence in your investigation at that point, was it not?
I thought so.
And I take it that you attempted to talk to this person who sold guns to a supposed Donovan Goudreau, who you knew was a former friend of Lyle's, that you attempted to talk to her in an atmosphere where she would understand what you were doing and you would understand what she was saying.
Yes.
And was there some reason, Detective Zoeller, when she told you that she had no recollection whatsoever of the transaction, that you didn't call her back a few days later and ask her, well, have you had time to think about it? Has anything, come to mind?
No, I did not call her back.
And wasn't that because you didn't think she had any memory for you to ask her about?
Objection calls for speculation. Overruled.
I didn't think she had any more to add, is why I didn't call her back.
And she really couldn't tell you anything except what part of the forms were in her handwriting and what part weren't.
That's correct.
She didn't even remember the driver's license.
That's correct.
Do you know if she was interviewed by anyone before she testified in 1992 before the grand jury?
I'm not sure. No,
Did you interview her?
No.
Were you present outside the grand jury room when this case was being presented to that body?
Yes, I was.
And did you see her there?
Yes.
Did you talk to her?
Yes.
Did you talk to her about the subject matter of her testimony before the grand jury?
I don't believe so, no.
Do you know which, if either, of the prosecutors in this case talked to her about the subject matter of her testimony before she testified before the grand jury?
I don't recall.
Did either prosecutor in this case come to you at the time of the grand jury testimony of Ms. Geyer and tell you she has new information?
No, they did not.
That didn't happen until June of 1993.
That's correct.
Now, what significance did you think it had? I'm changing the subject. What significance did you think it had? Which piece of paper fell off the coffee table and wound up on the floor next to Mrs. Menendez? What did that mean to you as a homicide investigator?
It didn't have any significance to me.
You didn't think, did you, that the shooters somehow placed that particular document on the floor next to Mrs. Menendez, did you?
No, I did not.
And it's true, is it not, that a very large number of photographs were taken of the family room den area that night?
That's correct.
And that would be standard procedure to photograph a good deal of the crime scene.
Yes.
And in fact, there were also photographs taken of just about every other room in the house also,
That's correct.
but not as extensively.
That's correct.
And no photographs were taken of the rifles in the closet.
No, there were not.
I have nothing further.
Anything else?
Yes, Your Honor, thank you. Detective Zoeller, you indicated that in about June of this year, you were contacted by the district attorney's office
That's correct.
to get a hold of Amanda Adams.
Yes.
And did Mrs. Bazanich contact you?
Yes.
Did she indicate that?
I'm going to object to what Mrs. Lozanne said, Your Honor, based on the hearsay.
Overall,
Did
not
she-
received for the truth of the matter asserted, but just to reflect what was said.
Did she indicate to you that she had received a call from Amanda Adams and that Amanda Adams had some information for you?
Yes,
Did you call Amanda Adams at that time?
I did.
Did you get a further report at that time?
I did.
Do you recall what she told you?
I'm going to object to this, Your Honor, it's hearsay, no foundation.
Overall,
Yes.
What did she tell you?
She told me that she remembered after thinking about it, remembered the sale of the guns, that one individual came up and knew exactly what weapon he wanted to buy, to purchase. He asked for two, and she asked whether he wanted her to show her how to work it, and he said no, and that he just got the guns and purchased them. There was not much time spent with her.
And that is consistent with how she testified in this case before
Objection,
these
Your Honor,
juries.
calls for inclusion on part of the witness
Sustained.
argument.
Nothing further at this time, Your Honor.
all right, anything else on the subject?
Is that common in your experience, Detective Zoeller, that a witness with utterly no memory 3 years later comes up with details like that when they haven't been hypnotized or drugged or suggested to in some way?
Objection, argument of compound.
Sustained.
Nothing further.
All right, let me see counsel at the sideline here for a moment. We're going to be continuing on for a little bit with the blue jury only. So what I'll ask is that the gold jury go back to the jury room. And before the noon hour, we'll have you come back and give you more information. But at this point, go to the jury room. Don't discuss the matter with anyone. Don't form any final opinions about it. Please be available in the jury room so that we can get you back here, and we'll let you know what's going on as soon as we complete this bit of testimony. All right, that jury has left, and you may continue the examination of the witness before the Eric Menendez jury only.
Thank you, Your Honor. Your Honor, I have two plastic bags, each of which contains a pin tab spiral notebook. And each bag also contains a Beverly Hills property evidence tag. What I'd like to do is mark 320's next. Yes. The yellow one, 320, and the blue one, 321.
All right.
Now, Detective Zoeller, on November 17th, 1989, you interviewed Craig Signorelli at the Baker Square restaurant in Goleta, California. Is that correct?
That's correct.
And Goleta is in proximity to the campus of the University of California in Santa Barbara. Is that correct?
That's correct.
And during the course of that interview with Mr. Signorelli, he relayed to you what he said was a statement that he had received from Eric Menendez concerning how Eric and his brother killed their parents, correct?
That's correct.
And did he tell you that he hadn't told anyone else about this confession that Eric had made to him?
That's what he said.
And he told you he was worried about having this information.
Yes.
And so because he was worried, he wrote it down in a school book in case something happened to him.
That's what he said.
In January 25th, in fact, 1990, did you serve a search warrant on the home of Craig Signorelli looking for school books, such as the type one would write something in?
Yes.
And the two items that are in front of you, 320 and 321, are those two school-type notebooks that you removed from his home?
Yes, they are.
And did you, after you removed those notebooks, carefully examine them to see if, in fact, they contained any statement by Eric Menendez detailing how he and his brother killed their parents?
Yes.
And there is no such information in there, is that correct?
No.
It's not correct?
That's correct.
Thank you. That's all, Your Honor.
Any examination by the prosecution?
Yes, thank you, Your Honor. Detective Zoeller, was it January 25th, 1990 that you served a search warrant on, it wasn't Signorelli's school home, it was his family home, isn't that correct?
That's correct.
And that was in Calabasas?
Yes.
And that's his mother's house?
That's correct.
Now, pursuant to that search warrant, you recovered 2 notebooks, correct?
Yes, I did.
Exhibits 320 and 321?
That's correct.
Yeah, Coach Ryan?
Yes.
Now, the blue notebook is the one that was marked as Exhibit 321, is that correct?
Yes.
Now, this notebook indicates that there's 70 sheets in the notebook, is that right?
That's correct.
Did you count the number of sheets in that notebook?
I did.
How many sheets are in that notebook?
60.
It appears that some sheets have been torn out.
Yes,
Is that the way that you received it on January 25th,
it is.
90? Now, you've indicated that it was November 17th, 1989, when Mr. Signorelli gave you the information about the confession that Eric Menendez made.
Yes.
With respect to your testimony that he also had given you information that he had written down information that he had on Eric Menendez. in a
Objection, Your
notebook.
Honor, that misstates his testimony.
Restate the question. Objection sustained.
I'll ask another question.
Right.
Your Honor, I'd like to approach at this point.
Well, we haven't heard a question. There's no reason to approach.
Question is, did Craig Signorelli indicate to you that he had written down some information in a notebook?
Yes,
And was that information gotten by you on November 17th, 1989?
it was.
And was that one of the things that you were looking for when you served the search warrant on Mrs. Signorelli's house on January 25th, 1990?
Yes.
I'm showing you Exhibit 321.
Your Honor, I'd like to approach.
One moment.
Within this notebook, Detective Zoeller, did you find a notation that appeared to be by Craig Signorelli about information that he had on Eric Menendez?
Your Honor, I would like to approach. Object to the questions calling for hearsay.
Objection overruled. You can answer the question, yes or no.
Yes.
All right. Did you want to approach regarding that?
If there's going to be any further questions along those
There is going to be.
All right. You may approach. All right. Anything else?
Nothing further at this time, Your Honor.
Okay. Any redirect?
Just one question. Detective Zoeller, what was on the 10 pages that were pulled out of the notebook? Do you know?
No, I do not.
Nothing further.
Anything else? All right. Thank you. You may step down.
Thank you.
Any information?
Yes.
Okay, let's see, counsel at the sidebar. We're trying to get some more information regarding the next witness. We have both juries back in the courtroom. There was some other matter that counsel wanted to put on the record.
Yes, ma'am. There was testimony earlier during, I believe, Dr. Connor's testimony. We identified letters, a group of letters that were taken from a box that was in Mom Menendez's car. One of those letters, which were marked as 316.
There's any reason why blue jury should be here for this?
Was this evidence only in relationship to the Lyle Menendez jury?
Correct.
Yes.
Okay.
Higher issues.
All right, then we'll deal with it only in relationship to that one jury. And as to both juries, what's happened is that there was a witness who was scheduled to be here and testify, but that witness has had difficulties in his personal situation in relationship to the fires that have occurred, and that witness won't be able to be here today. And therefore, other than this brief evidence that is going to be offered by the defense that Ms. Lansing was referring to in relationship only to the Lyle Menendez jury, there won't be any more evidence to be offered today. The lawyers and I have some matters to discuss, and we'll be discussing them this afternoon. And after those discussions, tomorrow I'll be in a position to confer further with counsel regarding the status of the case as far as when you can expect to have the case go to the juries for deliberations. So at this point, let me remind you all not to discuss this case among yourselves, not to discuss it with anyone else, not to form any final opinions about the matter, and don't permit yourselves to be exposed to anything about this case in any form outside of the courtroom. You must make your decision based only on what happens in the courtroom and my instructions on the law. And we'll see both juries back here tomorrow at 9 o'clock. I'll ask that the gold jury just stay here just for a moment so we finish off this one issue, and then we'll let you go as well for the balance of the day. So we'll see both juries back here tomorrow at 9 o'clock. The jurors have now all left, the gold jurors, and or strike that, the blue jurors, and now you may proceed in relationship to the gold jury.
Thank you.
There was testimony previously that a group of letters were removed from a box which had been in Lyle Menendez's car at the time of his arrest, and those letters were marked and identified. One of the letters, 316, begins, "Well, Lester," and it's dated November 18th, 1987. That letter came from Dr. Lester Summerfield's file, Mrs. Menendez's therapist, and not from the box as previously indicated.
All right, that stipulation of the parties is noted as to that particular letter as to where it originated. And at this point, then, we'll excuse the gold jury as well until tomorrow at 9 o'clock. We'll see you all back here at 9 o'clock. Thank you very much. And we'll be in recess in this court until 1:30 today. In relationship to the defendant's assertion of the attorney-client privilege in relationship to the the December 11th session with Dr. Oziel that was tape recorded. The court has heard testimony on this subject, and now we'll hear argument. Let me hear from the defense first.
Judge, the argument that we're relying on starts with the Supreme Court statement in People versus Kara. This is at page 1060 of the opinion. This is a case we cited in the court, and it says, the attorney-client privilege does attach to the defendant's communication to a psychiatrist assisting the defendant's attorney. And this is true whether or not the defendant puts his or her mental state in issue at trial. And then a similar statement of the same rule in the context of a situation where the court appointed an expert under Evidence Code Section 730-1017 is in People versus Horn. This is at page 619, where the Supreme Court says, because Dr. Weinberger was appointed to examine defendant at the request of his counsel, any statements he made to her for the purpose of obtaining a diagnosis for counsel's use in preparing a defense were subject to both the psychotherapist patient privilege and the attorney-client privilege, unless the defendant waived those privileges or an exception permits disclosure. So 2 points from those two cases. One is that it does not seem that the attorney-client privilege depends upon whether the psychiatrist is hired. Counsel for the People has cited a case from Arkansas, and that case from Arkansas deals with an Arkansas statute in which there's a specific definition of how an expert is brought into the attorney-client privilege, and it specifically says the expert has to be hired as in employed. Since the expert in that case was not hired, he isn't covered by the privilege. I think in California, as long as the psychiatrist or psychologist in this case is utilized by the attorney to assist in the preparation of the defense, he or she is covered by the privilege, regardless of whether there's a court order appointing the expert under 730 and 1017, and regardless of whether there's any financial arrangement between the attorney and the expert. And it's our position that as long as the expert is brought in to do the session for the purpose of conducting or assisting the defense, that it's covered by both privileges. And it also appears that the Supreme Court takes a very liberal approach to extending the protection of both privileges in a situation such as we have here, because in People versus Lines, there is a situation where the trial court appoints an expert under 730-1017 of the Evidence Code. And as the court goes for making those types of orders, the purpose of making a 730-1017 order is solely for defense purposes. The court is not acting as the instigator of a psychotherapist patient privilege in that situation. And yet in Lines, the court describes the nature of the relationship which results from a 730-1017 appointment. And the court says, in the case at bench, Doctors Abe and Markham were appointed by the court for the purpose of examining defendant for his own benefit and of fully informing his counsel as to the nature and extent of defendant's mental condition, to the end of assisting counsel in the preparation and presentation of the defense. What this arrangement amounted to, in effect, was that defendant, through the doctor as an intermediate agent, communicated to his attorney information as to his mental condition. To put it another way, all information obtained by the doctors from their examination of defendant and the reports thereof furnished to his attorney constituted confidential communications protected from disclosure by the attorney-client privilege. And the court goes on to say that the psychotherapist patient privilege also applied, but that an exception was applicable in that case because the defendant had put his mental condition in issue.
Let me just ask on Lines, People versus Lines, was Dr. Abe or Dr. Markman appointed to conduct therapy or some remedial activity in regards to the defendant, or just to render advice to counsel?
Just to render advice, because the court's description is on December 27th. On defendant's motion, the court appointed pursuant to 730 and 1017 of the Evidence Code, Doctors Markham and Abbey. So in that situation,
You'll get them both right. It's Markman and Abbey.
Abbey.
Okay. Abbey.
Whatever. So in that situation, the court is not appointed for purposes of therapy. Yet the court seems to be taking the position here that something that is solely for legal purposes can also be covered by the psychotherapist patient privilege. And it's our position that it would work the other way as well. That is, the court in its proposed factual findings characterizes the December 11th session as being for the purpose of therapy. And yet, if the Lyons analysis is correct, it can also be true that if there is a legal motivation behind that therapy, then it would be protected by both privileges. And the test seems to be a motivational test. That is, you can have a strictly therapeutic session, but if that therapeutic session is motivated by a legal purpose, it would be protected by both privileges. And I think the court can see that that is the test from looking at the Court of Appeal opinion and the Supreme Court opinion in this case, that is in Menendez, because the Court of Appeal, as a court will recall, decided the issue of the psychotherapist patient privilege insofar as the December 11th and November 28th sessions were concerned by looking to the motives of both the Menendez brothers and Dr. Oziel. And the Court of Appeal says, in its opinion, that Dr. Oziel's main objective was to ensure his own safety in the face of petitioners' threats. To petitioners, Dr. Oziel's primary role was not that of a therapist who could provide treatment for their emotional problems, but an individual who, if he could be trusted, could portray them from a sympathetic viewpoint if they were arrested and tried for the murders. And then at the very end of its opinion, the court says, in this case, it is evident from the record that from the time petitioners threatened Dr. Oziel, the doctor's primary objective was not to provide treatment to petitioners, but justifiably to protect his own life and the lives of his family and Smith, who were only in danger because of their association with him. Petitioners' primary objective was not to receive therapy, but to provide themselves with a possible psychiatric defense. The latter two sessions focused primarily upon topics which might aid petitioners should they be arrested and tried for the murders. And then the court says, since that was the case, there was in fact no therapy, and the psychotherapist privilege didn't apply. Then the Supreme Court's answer to that.
Let me ask before we get there, what
Yeah.
was the defendant's posture in the Superior Court in relationship to those findings that, or the evaluation of the Court of Appeals? Was that consistent with the defendant's position in the Superior Court?
It was, because the position of the district attorney was initially in the Superior Court that the sessions came within Evidence Code Section 1018, which was the exception which had to do with fabricating a defense. And their position was that the psychotherapist patient privilege did not apply because it was clear that the purpose of the December 11th session was to fabricate a defense. The defense's position was that there was no evidence to suggest fabrication of a defense, and to the extent that there was a motivation which centered on a defense, that was covered by the psychotherapist patient privilege. And that was argued, in fact, in the moving papers, which were filed in front of Judge Albrecht.
And then in the Supreme Court, did the defense take that position as well, that this was not a therapeutic session but had some other purpose?
No, they took the position that a session which has as its motivation a legal purpose is a therapeutic session for purposes of the psychotherapist patient privilege. The way it was phrased these are the moving papers I'm referring to in the Superior Court, the written argument was, as for diagnosis, the person could be seeing the doctor in order to see whether in fact he had any legitimate or mitigating defense. And then the argument was made that if that was the case, as opposed to a motivation which centered on fabricating the defense, that the privilege was covered. And then in answer to that response, for purposes of the psychotherapist patient privilege, the California Supreme Court says, in any event, motive is largely, if not totally immaterial. Motivates the participants is not psychotherapy for its own sake. For example, a psychotherapist is sometimes motivated by self-interest, as when he earns his living solely through his practice. For his part, the patient is sometimes motivated by self-preservation, as when he struggles to resist the temptation of suicide or antisocial conduct. As a general matter, the dispositive fact is what the participants do, not why. And then the court says, but see Evidence Code Section 1018. And that reference to Evidence Code Section 1018 seems to suggest and does suggest that where the applicability of the privilege depends upon motive, as it does in 1018. The exception embodied in 1018 says if the therapy is sought for the purpose of fabricating a defense, then the privilege does not apply. So the Supreme Court here is indicating there may be some situations where motivation does become important. 1018 is one example. It's our position that motivation is also important in order to determine whether the attorney-client privilege applies. Because as framed in Clark and in Lines, the court seems to be adopting a motive-based test. That is, if the therapy session has a legal motivation behind it, and if there is an arrangement between the psychologist and the lawyer where the lawyer has enlisted the psychotherapist to aid in the preparation of the defense, the privilege would apply, even though standing alone, the session appears to be a session for purposes of therapy. And so it's our position that there's nothing in the court's proposed findings that where the court finds that the session of December 11th was for the purpose of therapy that prevents us from asserting an attorney-client privilege here. Because under the cases we cited, I think the question is, if it was for the purpose of therapy, what was the motivation behind that therapy?
Well, let me interrupt and ask, what is the defendant's position in relationship to the December 11th session? Was it for the purpose of therapy? Do you dispute that?
No, it was for the purpose of therapy, and the purpose of the therapy was not, in the words of the Supreme Court, psychotherapy for its own sake. It was psychotherapy motivated by a legal purpose. And it's also our position that if the
Supreme Court doesn't use that language, that's you've added that as far as the legal purpose.
Correct. In other words, when they're referring to psychotherapy for its own sake, and they cite as an example, well, the psychotherapist is motivated by self-interest, he wants to make money. The client may be motivated by self-preservation. That analysis would seem to apply to a client who is motivated to prepare a legal defense. And it's our position that this was psychotherapy, but it was motivated by a legal purpose. And it's also our position that if the brothers had just gone into Dr. Oziel with that motivation in mind and said, I'm conducting this psychotherapy because I think down the line it may be of use to me in my legal defense, that's probably not covered by the attorney-client privilege. What makes it covered in this case is the intervention of counsel. And it's our position that the facts are that the situation reached a point in time where a decision had to be made as to whether or not therapy was going to continue. And that at that point, that is after the meeting between, or on or about the time of the meeting between Chalif and Oziel around November 27th, and also including up to the time of December 11th when Chalif is there present during the sessions, that it was within the control of the lawyer at that point.
Well, he was not there for the therapeutic session that is at issue here.
No, but he was there, it's our position, to decide whether that session should go forward for legal purposes. And we indicated to the court the other day that all the evidence in front of the court indicates that had he advised the brothers that the session should not go forward, that they would not have nevertheless stayed there and conducted a therapeutic session. That it was within Chalif's decision-making process at that point to do what he was brought into the case to do, which was to advise the brothers as to whether they should continue in a therapeutic relationship and hold therapeutic sessions with Oziel, and that he made the decision and advised them that he thought there was some legal purpose to be served by doing that in terms of penalty phase preparation or whatnot, and that the brothers, acting on that advice, went ahead and had a therapeutic session. And it may have been therapeutic for its own sake in the abstract, but it's our position in the context of what had gone on before in this relationship, that this was a therapy session which was looking down the line to using the results of this therapy the fact that they were receiving therapy in a legal context and specifically in a penalty phase context if they ever got that far. So the factual argument here is, but for the decision of Chaliff, that session would have never taken place. And the fact that it did take place under his direction brought it within the protection of the attorney-client privilege.
Okay, anything else on behalf of the defense?
No, Your Honor.
By the prosecution?
Yes, Your Honor. As the court knows, the burden is on the party claiming a privilege to sustain the fact of the privilege's existence. And in this particular case, the people are not aware of all of the facts upon which the defense relies. However, I think we have a sufficient idea of what the facts are in order to address the issues. The mere fact that one has in one's employment a psychotherapist and an attorney simultaneously does not convert the relationships into the psychotherapeutic relationship into one covered by the attorney-client privilege. We've cited to the court an Arkansas case, and luckily it includes the statute. And the statute is different from the California case, but the principle is similar. The principle is that just because someone takes a statement for you for one purpose and you have an attorney doesn't mean that that attorney is the statement that was taken by another person who was not engaged in or in California reasonably necessary for the transmission of the information or the accomplishment of the purpose for which the lawyer is consulting. Now, in this particular case, it's very clear that the defendants had a long-standing prior relationship with Dr. Oziel, which predated the murders of their parents. In addition, we know that shortly after the murders that Mr. Chaliff appeared on the scene, but that discussions at the end of October and early November were certainly done without the consent, advice, or in any way. It doesn't appear that Mr. Chaliff was even aware of those particular sessions before they occurred. The mere fact that Mr. Chaliff might have been aware of the December 11th tape does not convert that relationship into one which is contemplated by cases like Lines and Arcega. The footnote that we highlighted for the court today in Lines, footnote number 12, is indicative of the fact that what Lines was contemplating is where an attorney hires or in some way engages the services of a psychotherapist in order to evaluate his client for the purposes of litigation or for the purposes of the attorney's representation of that particular person. Clearly, that fact situation is not applicable in this case, at least from everything that the people are aware of. Now, early on in this case, the defendants took the position that their sessions with Dr. Oziel were for therapy, and that particular position of theirs was pursued into the California Supreme Court. It's somewhat ironic that the defense is now citing the Court of Appeals findings of facts to somehow support its position that this court should find that the attorney-client relationship supersedes and overtakes the psychotherapist-patient privilege, which has now been waived by this court pursuant to Section 1016. Waived by the court is not the correct terminology, but which has now been found by this court not to apply. The defendants have always taken the position up until proceedings in this court, which were prompted by the people's motion, that the session of December 11th was for the purpose of therapy. I might ask the court to consider when, if at all, the relationship changed between Dr. Oziel, Mr. Chaliff, and the defendants, and how, in fact, that relationship changed. It appears that these two questions might, in fact, be answered only by the defendants, and I would ask the court to consider the testimony of the defendants in this courtroom in the trial, and their own admissions of untruthfulness, and as well as the people's impeachment of these defendants in various ways, which has not yet been finished because it hasn't been followed. We know from as recently as Mr. Fenno's testimony that both defendants were in the habit of telling their parents lies. Mr. Menendez often told his parents detailed lies. It appears that what is contemplated by Lines and the other cases interpreting the joinder of the psychotherapeutic and attorney-client privilege is not the situation which is presented in this case. The people have cited since we filed this motion, a number of cases which deal with this particular issue. I know Mr. Burt filed with the court today a case revisiting the issue of when mental condition is put at issue. The people have given the court a more recent California Supreme Court case, a different Mr. Clark from 5 Cal 4th at page 950, which again discusses the idea of mental condition being put at issue. And I think since Mr. Burt did not address that in the argument that that is perhaps an issue which is probably moot at this time. But in terms of the attorney-client privilege and its applicability to the 11th of December, there is no evidence of which the people are aware which would cause the defendants to have met their burden of proof in showing that the session was conducted for the purposes as outlined in Evidence Code Section 952, which is where disclosure is reasonably necessary for transmission of the information or the accomplishment of the purpose for which the lawyer is consulted. The defendant seemed to change the facts as the situation warrants, and I think that in light of the evidence which was painstakingly and adduced and done ex parte by these defendants in front of Judge Albrecht and then pursued in the Supreme Court, that they are hard pressed now to turn to other means in order to convince this court that in fact it wasn't merely for therapy but for other reasons. The people would submit that the defendants have not met the burden of proof. The attorney-client privilege does not apply to the session. I would like to point out that there were many subsequent sessions which occurred between Dr. Oziel and the defendants. It does not appear that this privilege is being pursued as to those subsequent sessions, which I believe is further proof that this particular assertion of the privilege is being done solely for the purpose of changing the facts to protect the guilty. Thank you.
All right.
Just briefly in response, we're not abandoning the argument on what constitutes a mental condition. It's my understanding we're arguing the attorney-client privilege issue solely at this point. And in terms of the factual analysis by the people, this is not a situation where the sole testimony in front of the court is the defendant's own testimony concerning what the purpose of this session was. The court has ample evidence before it from the people's own witness, Dr. Oziel, as well as not only from his testimony, but from the session notes of November 2nd, which indicated at that point Oziel interjecting the issue of whether future sessions could be used for some legal purposes. The court also has in front of it the testimony of Mr. Chalin, backed up by documentary evidence as to what happened on November 27th in terms of a meeting between Lyle Menendez and Mr. Chalin and the establishment of an attorney-client relationship at that point. And Mr. Chalin's testimony as to what the purpose of that consultation was and what actions he took, and the fact that the actions he took were corroborated by his calendar entries. So it's not simply a situation where the defendants are coming in and changing the facts to fit their own purposes. I think all the evidence in front of the court, and in fact in front of Judge Albrecht, support the interpretation which we take here, which is, yes, this was a therapeutic session, but what motivated the session was not therapy for its own sake, but a specific legal purpose in mind. And we are not seeking to reverse the factual findings. In fact, the purpose in citing the Court of Appeal opinion was to illustrate to the court that those who had actually looked at the content of the sessions saw the sessions as being motivated for possible legal purposes. So I don't think there is anything inconsistent with the position we're taking here and the position we took in the Supreme Court or in the lower courts on the first go-around on this issue. The fact of the matter is the attorney-client privilege issue was not addressed for whatever reason, and the courts at that time did not have all the information in front of it that you have at this point as to what led up to the sessions of December 11th. And with that information in mind, it is a situation not where we are seeking to have the fact that Mr. Chaliff was aware of sessions retroactively converted into being sessions protected by the attorney-client privilege. But we're not saying that because he became aware of these sessions, therefore all the therapy sessions which were occurring up to that point were protected by the attorney-client privilege. Rather, it's what happened on November 27th and following which leads to the specific indication of the privilege as to that December 11th session. And the fact that we are selectively invoking the privilege is no indication that the privilege is not valid. In fact, just the contrary. We're not seeking a broad-based rule here that because a lawyer got involved in a picture that everything that was done was protected by the privilege. It's just that the testimony in relation to this specific session indicates that it comes within the protection of the privilege.
I would just want to add, Your Honor, that we have asserted the privileges to any subsequent sessions. We just don't have any idea what Dr. O'Ziel would say about this. There's no news.
We did have some discussion of that earlier when we had argument on this subject prior to taking further testimony, and Ms. Abramson did state her position and that of her client that she is asserting the attorney-client privilege to any sessions subsequent to December the 11th as well. All right, did people wish to respond?
Just very briefly, Mr. Burt makes reference to the fact that in the November 2nd session, Dr. O'Ziel talks about helping the defendants should they ever be apprehended. That does not indicate at all that he's working on behalf of Mr. Taylor at that time. And rather, in fact, would show that the two relationships, that is the one between the defendants and their therapist and the defendants and their attorney, were existing on parallel, non-intersecting claims. The other thing, it appears that the defendants are arguing that the Court of Appeals findings of fact are circumstantial evidence of the contents of the tape, insofar as the findings of fact were rejected as not being supported by substantial evidence by the Supreme Court. I don't think the defendant should be permitted to make that argument. And that's all I have.
Let me inquire. The defense indicated at some point if a ruling was made against the defense on this subject, you would intend to call Ms. Smith as a witness. And my only inquiry in that regard is whether or not any of that proposed testimony relates to the subject matter of this hearing today as to whether or not there was or is a valid attorney-client privilege assertion, so that we don't get to a ruling and somehow later on there's some evidence that you bring in that relates to that subject. I don't know what it is that you're proposing in her testimony, if at all.
We're not going to be offering further evidence from Ms. Smith on the question of whether the privilege applies. Her testimony may touch on the circumstances leading up to the December 11th session, insofar as those circumstances would be put into issue by the prosecution or by us. But we're certainly not going to take the position that something she says is new material and should be considered by the court on a question.
And other than the one brief portion of the December 11th session that was transcribed and presented to the court last Friday, is there anything within that session, the transcript or tape recording of it, that the defense believes deals with or addresses factually the subject of attorney-client privilege as to whether there is a valid assertion of that privilege?
No, Your Honor. I think the content of the session is accurately described by all three courts that have considered the matter.
As a therapeutic session?
Correct. And as to what the substance of the session is, if that somehow plays into the court's analysis, if the court is referring to what's in the content of the session, I think that the other courts have addressed the content, accurately described it. If the court is referring to whether there's any other portions of the session which address whether the purpose of it is legal or not, there's not, other than the reference that we brought to the court's attention.
All right. Is the matter then submitted?
Yes.
Yes.
All right. The issue before the court is one that has taken a considerable length of time to get here in this posture. It was the subject of litigation at various stages on various issues. After the defendants were arrested, and or shortly after these tape recordings were seized, hearings were conducted in the Superior Court in relationship to the defendant's assertion of attorney-client privilege as to all sessions that occurred between, strike that, the hearings in the Superior Court related to the patient-therapist privilege, and as to all sessions that occurred between the defendants and Dr. Oziel. And ultimately, the issue at that time in the Superior Court involved 4 sessions which were found to be non-privileged by the Superior Court. And at that time, the issue of privilege related only to the patient-therapist privilege. The Superior Court articulated reasons why those sessions were not covered or protected by the attorney, or strike that, the patient-therapist privilege. The Superior Court made findings of fact in relationship to all 4 sessions, and specifically in regards to this session of December 11th. The Court of Appeals reviewed the Superior Court's findings and application of law to those findings, and for different reasons supported the Superior Court's analysis as far as the ultimate conclusion that the 4 sessions were not privileged. The Supreme Court then reviewed the ruling of the Court of Appeals and concluded that the first 2 sessions of October 31st and November 2nd were not privileged, and the latter 2 sessions, November 28th and December 11th, were privileged. And again, the Supreme Court only addressed the the patient-therapist privilege. The attorney-client privilege was never brought up during the Supreme Court hearing and was not addressed by the Supreme Court. Since the Supreme Court found that the patient-therapist privilege applied to the latter 2 sessions, this trial was conducted with the Supreme Court's ruling in mind, and the court was fully aware and very supportive of the ruling of the Supreme Court and all intentions of enforcing that ruling in its entirety and making sure that the ruling of the Supreme Court was enforced throughout the trial. And at various times during the testimony of Dr. Oziel, the issue arose regarding or relating to whether there had been a waiver of the patient-therapist privilege. We dealt with that several times at the sidebar and in other discussions relating to Oziel's testimony. The people's position at various times was that because of cross-examination of Dr. Oziel, that the defense, in essence, was not using the patient-therapist privilege in relationship to the last 2 sessions as a shield, but actually as a weapon, offensive weapon, to take advantage of the situation that those sessions were privileged and somehow portray Oziel's testimony in a different light than would otherwise occur if those sessions were ruled not privileged. However, the court sustained the defense position that those sessions were privileged throughout the testimony of Oziel and found that there was no actual waiver by the defense, regardless of the nature of the examination of Oziel. And during that phase of the trial, the people filed with the court a motion relating to the tender by the defense of a defense of relating to mental or emotional condition. This was done early in the trial prior to the people resting, as my recollection is prior to the opening statements, if my recollection is correct. The people apparently anticipating that the defense might tender such mental or emotional condition at some stage during the proceedings. After the people rested, the defense proceeded with its evidence. At various stages, there were discussions with the court regarding whether the mental or emotional condition had been tendered by the defense to the point where there could be a ruling or should be a ruling by the court that there was a waiver by the nature of the evidence offered by the defense. The defense took the position very forcefully that there was no such waiver, that the mental or emotional condition exception or waiver had not occurred, and that the sessions of November 28, December 11th were protected by the patient-therapist privilege. And towards the end of the, or in the middle of the people's case, during the testimony of Dr. Oziel, after the people had given notice of its intent to pursue a hearing under Section 1016 of the Evidence Code, the defense indicated that it would also assert the attorney-client privilege in relationship to the December 11th session. Some testimony was taken ex parte, that is, without the people represented, from Dr. Oziel on this subject. Some testimony was taken from both defendants and Mr. Chaliff. And then the matter proceeded with the defense offering further evidence in its case, and including the testimony of both defendants and the various psychologists who have testified on the subject. After all of those psychologists have testified and the defendants have testified, at that point, the court felt that it was appropriate, having heard all of the evidence to be offered at that stage anyway, relating to the subject of the defendant's mental or emotional condition. The court felt it appropriate to rule on that subject as to whether or not Section 1016 and its language applied to the situation, that there was an exception, that the defendant's mental or emotional condition had been tendered by the patient defendant. And after extensive argument and review of the evidence and evaluation of the case law, the court ruled that there was grounds to and a basis for and requirement, actually based upon what was presented, a requirement that the exception under Section 1016 apply, that the court found that what had been tendered here was the mental and emotional condition of the defendants. And I'm quite satisfied that that is what occurred, and I'm quite satisfied that that ruling is a correct ruling. Then the issue became whether the attorney-client privilege would apply to this issue, to this session of December the 11th. The court indicated to counsel on October the 28th that it had reviewed the evidence presented by the parties, specifically the defendants, and had come to certain conclusions as to the factual issues that had been presented. And the court prepared findings of fact regarding the December 11th session and presented those findings of fact to the parties, both the defense and the prosecution. The defense, after reviewing the court's findings or proposed findings as they turned out. The defense then requested permission to present additional evidence to the court to clarify, in the defendant's view, certain issues that arose or were addressed in the court's factual findings. The court did permit the defendants to testify further on these subjects, and that occurred this past Friday. Again, the prosecution was not present for the testimony. The defense also offered, by way of offer of proof, additional testimony from Mr. Chaliff on that subject. The court has indicated that it would not permit additional testimony from Mr. Chaliff, that the matter had been completely litigated earlier on that subject. But I do understand the offer of proof as to what Mr. Chaliff would say in that regard, to clarify whatever it is that the defense felt needed to be clarified in my findings. Having reviewed all of the evidence presented to the court and all of the matters presented to it on this subject, the court is of the mind and view that the findings of fact that I set forth in writing on October the 28th, 1993, are still the findings of fact and are the findings of fact of this court that I make at this time. I find that nothing that I have heard by way of further evidence or offer of proof would cause or does cause me to change my findings of fact. I am satisfied, based upon the entire review of the evidence offered here and the review of the testimony of all the witnesses, as the court is required to do, and evaluate the testimony of all witnesses, judge all issues relating to that testimony. The court finds that the facts as I've set forth in my findings of fact of October 28th are the facts in this case and are the findings of fact of this court. The court further will evaluate and review the findings of fact in the context of the legal arguments presented by counsel here as to whether or not the session of December 11th is covered or protected by the attorney-client privilege. I reviewed section 952 of the evidence code, which is the issue, or the section rather, that deals with this issue. I reviewed all of the cases presented to me by all sides. I think all counsel would agree this is a unique situation, one that factually has not been addressed by any other case in any other context. The court finds that in regards to the December 11th conversation or session between Dr. Oziel and the defendants, that this was not a confidential communication between a client and a lawyer, as defined in section 952 of the evidence code. This was a therapeutic session of the defendants and Dr. Oziel, whose disclosure was not reasonably necessary for transmission of information to the lawyer or for the accomplishment of the purpose for which the lawyer was consulted. And also for, based on my analysis, does not constitute and because of that, does not constitute a confidential communication between the client and the lawyer. This was a session that was designed for therapeutic purposes of the defendant, both defendants, and between them and Dr. Oziel. And just because Mr. Chaliff was counsel and hired to represent the defendants does not create or make this a confidential communication between the defendants and Mr. Chaliff, or a communication using Dr. Oziel as a conduit for the purpose of transmission of this to Mr. Chaliff, or for the purpose of accomplishment of the purpose for which Mr. Chaliff was consulted. The court finds that this is not a confidential communication and therefore is not covered by the attorney-client privilege. And therefore, the assertion of that privilege will not be honored in regards to that session. All right, anything else in regards to this subject?
Not on the attorney-client privilege, but there still remains a question on the psychotherapist patient privilege as to whether specific areas of this session are still covered by the psychotherapist patient privilege because they are not relevant to the mental or emotional condition put in the issue.
How did you propose to deal with that?
We would request an in-camera session at this point so that we could outline for the court our arguments in reference to why certain portions are not relevant. As an initial matter, we, in citing the court to the Spencer case, wanted to ask the court to, and do ask the court to revisit the issue of whether we have put mental or emotional condition in the issue, since the Spencer case seems to indicate that it does have to be something in the nature of a diminished capacity, epilepsy type of defense. And that was the purpose in submitting that to the court. And if the court were to overrule that objection, then it would be asking the court to go in camera for the purpose of presenting to the court argument as to why several passages in the December 11th should not be subject to disclosure because they were irrelevant to the mental or emotional condition the court has willfully placed on the issue. All
right, I'm satisfied that the mental and emotional condition exception of Section 1016 applies, and even in light of the language in the Spencer case.
Then we would be requesting an in-camera hearing for the purpose of presenting an argument as to why certain portions are not relevant.
How are you going to identify those portions? You want me to read the transcript so that we can get some feel for what it is that you're going to argue? Otherwise, I won't know what you're referring to.
Yeah.
Do you have a copy from
Yes, and even though, as we argued to the court before, we don't think we're legally obligated to do that, we will be doing it in this case, so that the court can review the portions of it that's removed.
Your Honor, we're prepared to report that transcript.
Yeah, and it doesn't constitute any waiver regarding those matters that are not relevant, just to expedite the hearing. Otherwise, we'd be talking in the abstract without knowing what the details are. All right, if you have that, let me look at it, and we'll take a recess, and I'll permit you to argue the matter ex parte. So why don't you give it to the clerk and.
We can do that, and then there's one other matter, Your Honor. The court has not reached the point where it's actually handing over anything yet, but there are certain portions that the court will review, which we're fairly confident the court will find to be relevant. And in light of that fact, we would ask the court for a stay of its decision so that we can seek pretrial appellate review of the court's ruling, since this is an area of privilege. If the court is wrong in its analysis, it's not going to do us much good on an appeal if the privilege information has already been disclosed. So we would ask the court that in the event the court finds that certain portions of the December 11th session are to be turned over to the prosecution, that the court stay its order for a week to allow us to pursue a pretrial writ of the issue.
All right, let me first review the document. And did the people wish to be heard on that issue?
The people are opposed to staying on.
And did you want to articulate any reasons at this point as to why you're opposed?
Yes, because the court has made findings of fact, which are the underpinnings for the court's decision. Once the court makes these findings of fact, the law follows quite naturally. And it's very clear, especially even in this case, Menendez v. Superior Court, the findings of fact, which are supported by substantial evidence, are not to be disturbed, and therefore this particular the defense seeking appellate review would be fruitless, considering the fact that this is something that was based on findings of fact.
Well, Judge Albert made findings of fact as well, and as we know from the subsequent litigation, it didn't exactly dictate what the result was in the Supreme Court. This is a rather unique situation in that the Supreme Court has ruled that these specific sessions are subject to the privilege. And I think it is an issue which we would be obligated to pursue, and of course we couldn't do that if the court ordered immediate handing over of these tapes. And that's with all due respect to the court's analysis. As we know from the prior history of this case, sometimes the higher courts have a different view of things.
You are entitled to disagree with this court's rulings, and so are the appellate courts. All right, I will review the transcript. How many pages is it?
29.
This version was 29.
Okay, and we'll take a looking at the clock. It's not quite up to our current standard time, but we'll take a recess of until 3:15 to permit the court to review it, and then I'll talk to counsel ex parte, and then we'll proceed from there. December 11th conversation between Oziel and the defendants is not relevant to the mental or emotional condition that has been tendered by the defendants. I have read the transcript of the tape recording, and based upon the arguments presented and my review of the transcript, I find that the entirety of the transcript and the tape recording is relevant on the issue of the mental and emotional condition. That is separate and apart from other objections that may be lodged by the defendants to the admissibility of portions of the tape recording, which will be separately addressed with the prosecution. Therefore, the court is in a position to now rule on the defense request for a stay. Did you wish to argue the matter further?
Just to indicate to the court that we really would have three separate requests, and our first request would be that the court stay the trial and the court's ruling for a week to enable us to seek appellate review. And if the court was not inclined to grant that request, then we would ask the court for a stay of the court's ruling disclosing the tape to the prosecution. In other words, under that proposal, the court would go forward with the trial, but it would give us 1 week to perfect a pretrial writ before the court handed over the tape. And then the third alternative, if the court denied the first two, would be to ask the court to stay the prosecution presentation of the tape for 1 week to again give us the opportunity to seek appellate review. And under that proposal, it would be our position that if the court, over our objection, gave the prosecution today the content of the tape, that would not be a waiver on our part. And if we had a week in which to seek pretrial appellate review before the prosecution was entitled to put that tape in evidence, we could take the position that the appellate court could stay for the presentation of the evidence.
All right, do the people wish to be heard on those three requests?
Yes, Your Honor, take the position that it's the same position we had before, which is that we don't think that there's going to be an issue that's going to be appealable. But if the court is inclined to give the defendants a chance to pursue any kind of appellate remedy, we would obviously prefer option number 3, which the reason that we would like to have access to the tape now is because it will determine how much and what kind of rebuttal we're going to put down. And, unless and until we know the contents of the tape, we really are not in a position to proceed. especially in light of the fact that we would like to finish the trial as well.
All right, anything further? All right, the court denies request for stay and will turn over to the prosecution a copy of the tape recording. I don't know if the one that we have is the original or a copy or what is.
There's no copies, Your Honor. You have the, there never were.
All right,
Court
so,
has the original, and we think out of an abundance of caution, the court should have it copied before it turns anything over to the prosecution.
how was the transcript made?
Well, we have one copy.
I thought you said there were no copies.
No, we have a copy. I mean, there were no copies made by Dr. Oziel that we're aware of. When the safety deposit box was searched, there were multiple copies of October 31st, November 2nd. There were multiple copies of the old therapy, supposedly, but there was only one copy of 12/11 and only one copy of 11/28.
Right, and these are they.
Those are them, yes. I didn't think, I'm looking from a distance, I'm familiar with what they look like.
You have one copy of each.
We have one copy of each.
All right, then if I gave these to the prosecution to copy, then you would still have another so that.
We would have a copy, not a very good quality one, but we have a copy.
I don't see any reason not to permit the prosecution to take it for the purpose of copying. I don't see why we want to encumber things further. How long would it take the prosecution to make copies of these?
Till tomorrow morning.
All right, and you will ensure the integrity of these?
Well, I'm going to object to the court turning over 11/28 at this point. We've had no hearing about that
You're
whatsoever.
correct. That's right. That was something that you brought up and we wanted to discuss. You'll ensure the integrity of this?
Yes, Your Honor. The procedure is we're going to give it to Detective Zoeller, who will take it to the Beverly Hills Police Department and make copies on their machine, the same machine we've been making copies for the defense the whole trial. We'll then bring back the original to the court tomorrow to the lodge report, and we'll have a tape recorder and the defense can listen to it to make sure we didn't change it.
All right. Do you have a copy of the transcript for the prosecution so at least we don't, we can give it the.
I don't think it's appropriate for us to give the prosecution a copy
Okay.
of our work product, which is what that transcript is, except it's my personal work product.
Okay. Well,
They may be entitled to the tape, but they're not entitled to my work.
except that you're going to be using this and eventually it's going to be part of our discussions here.
Well, I think they're going to make their own transcript anyway. They have with every single tape all the way through the case. I don't think they rely on ours in any event. And I don't have it on disc, unfortunately. That's why the court today got some handwritten further corrections, because the person who transcribed it misplaced the disc. And therefore, I can't, if it was a matter of convenience, as I've offered to do with other materials for the prosecution, and we had it on disc, so it would shorten the job of redoing it. I would, but we don't have to have it on disc, so it is what it is.
All right, what I'll do then is order the clerk to make a copy of Exhibit 322 and make that available to the prosecution as well as the.
Your Honor, I specifically lodged that transcript with the court on the notion that that would not be done with it, and the court took it.
I'm sorry, that would not what?
That it was only being submitted to the court for the court's use. I specifically said that to them because I did not want it turned over to the prosecution.
Well, you didn't articulate that the reason was because it was work product.
Whatever the reason was, we lodged it with you to make it for the convenience of the court, so you didn't have to go back for an hour and listen to tape.
Well, I appreciate it. I'm not disputing any of that. I'm just trying to explore why we shouldn't give it to them so that we can expedite this thing. It's all going to be used anyway, isn't it? The transcript and everything else. Why are we, you're going to have a transcript, they're going to have a transcript if they want to make one, and it'll ultimately, both of them will be used. We're just sort of playing games here.
I'm not playing games. I just don't see that it's the defense's job to facilitate the prosecution's job. I've never understood that. I don't believe 115 goes quite that far.
No one is suggesting that it is, but at this point, the court will order that a copy of 322 be made so that it can be used for our discussions tomorrow relating to the admissibility of any portion of this tape recording for which the defense has objections on other grounds other than privilege. And in order to facilitate those discussions, we need something to refer to. All right, anything else at this point?
We would ask the court to inquire after the prosecution has had a chance to review the tape, what the prosecution's position is with respect to the other sessions that the court is aware of. Because
Yes.
that's an issue that we need to resolve because in anticipation of the people using the December 11th tape, we feel under compulsion of the court's order that we may have to anticipate that use and present the December 11th tape as part of our case in chief. And obviously, if the courts can rule other sessions unprivileged, we would also want to address those issues as well in our case in chief. And we can't do that until the people have articulated what their position.
Yeah, that was something that the defense brought up just before we resumed an open session with the prosecution present. Is this something that the prosecution is in a position to respond to now, or do you need to listen to this tape, or what?
We need to listen to the tape, Your Honor, and then we'll be in a position to address the other sessions and also the motion to have the defendants examined and things like that. So once we listen to the tape, we'll be in a better position to evaluate the kind of evidence we want to present.
And you'll be able to listen to copy the tape and listen to it tonight?
We're going to listen to it tonight. It will be copied early tomorrow morning. So we'll go to the station every morning before it comes here.
Okay. All right. So then tomorrow morning, hopefully the prosecution can present their position relating to all these other sessions.
Correct.
And then everyone will be in a better position to know where we're going as far as the defense and whether the defense will offer additional witnesses and the timing of it, so that then we can
We're intending right now
anticipate when the trial will conclude.
to call Juwan Smith tomorrow.
Okay.
Yeah,
All right.
she should take up a bit of time, I assume. And tentatively, based on this ruling today, and dependent upon what people say about the other information, right now it's my plan to call Dr. Vickery on Friday.
Okay.
But Your Honor, does that mean that we're not going to be presenting the Zoeller case this week? We have witnesses flying in and.
Well, don't have witnesses fly in, but have witnesses who are local witnesses available.
Locals.
I don't want to have any more dead time here where we run out of witnesses and nothing to do. And certainly, if one side is unable to proceed, we can still have the other side present witnesses. It doesn't have to come to a complete halt.
All right.
Well, we would, depending on what the people's strategy turns out to be on rebuttal, if we're having getting witness hear problems, we wouldn't object if they wanted to call a couple of witnesses out of order to feel forced to arrest.
All right, well, we'll deal with that, and the court will address that issue as to how we would proceed with witnesses out of order so that we don't have too much dead time. I'll make these, have the copy made and of the transcript and the tape recording will be provided to the prosecution. That's the tape recording of December 11th. And when they're returned tomorrow, we'll mark the tape as an exhibit, but at this point it'll be released to the prosecution to be returned tomorrow morning. All right, we'll be in recess until tomorrow at 9 o'clock.